So I'm the head of commercial property at So Legal. I deal with anything non-contentious to do with commercial property. Anything litigious goes to my esteemed colleague at the back there, Mr. Creasy, who will be happy to handle that. 20 years of experience. I know I don't look old enough. So my speciality is buying and selling commercial premises. Landlord and tenant work, that forms probably about 60% of my work. Developments, I sort of specialise in overage and conditional contracts, and also bank security and securing finance on property. And Max, if you'd like to do a little introduction of your good self.
Indeed. So I'm Max Pollock from Eightfold Commercial. Similarly, sort of been in the business for over 20 years like Hamish, but sort of I've probably aged worse than he has. We've been going a couple of years now. Things seem to have gone pretty well sort of for us on that respect, but generally dealing with sort of sales and leases of commercial properties, also acquisitions as well. And yeah, as sort of says up there, we sort of deal with a range of things, sort of retail, office, industrial, investments and developments. So hopefully you'll enjoy our speech this morning.
So what we thought we'd do is just run through the main heads of terms in a commercial property transaction. Max will speak from a landlord's perspective, what they would like to see in the heads of terms and achieve ultimately, and myself from a tenant's perspective. So heads of terms form the bones of a property transaction, and then, although they're non-binding, once they're transferred to the solicitors, they put the flesh on the bones in order to give effect to the main terms. So it's important that the terms are there in place to begin with, because it could save a lot of delays and potentially costs during the course of the transaction. I usually find that from heads of terms stage that completion takes place within 2 months, but obviously that could take longer or shorter. I'm sure you've seen some that have gone on for much longer.
Depends on the solicitor.
Yeah. So starting off with the agreed terms.
Okay, so from the landlord's perspective, obviously we've got landlord there, which can be sort of a number of different entities, sort of whether it's a company sort of or an individual. Sometimes you'll have a charity there. Similarly, with a tenant, sort of you'll have that where it can be a company sort of or an individual, depending on which the landlord will be getting sort of different levels of security. Obviously, if you've got a limited company and it's a new limited company, there's not too much substance sort of there, sort of as security for a landlord, whereas if you've got personal individual, it'll be a bit like the guarantor, as we'll move on to in a second, that there can be personal responsibility there on that individual and their personal assets. Anything to add on that?
So from a tenant's point of view, I often find that they, at heads of term stage, they put themselves down as the tenant individually, and then once they've spoken to their accountant, they've been advised it's more tax efficient to put it into the company, so they put it into the company. But as Max said, the landlord is likely to want a bit more security.
So sort of moving on there, where you've got a limited company that can be taking a property, or you've got an individual that's taken a lease personally, but they have limited assets or experience, a guarantor can be required. With that guarantor, what a landlord will be looking for is somebody that's got some substance to them, preferably sort of owns properties themselves, where equity can be seen in those, so that if there is a default, the landlord can look to recover that. In the instance where that's not possible, or alternatively the individuals taking the properties don't want to give a guarantor because they don't want to expose themselves to that level of liability, we can be looking at sort of a rent deposit instead, which, depending on the party coming in, will normally range between sort of 3 and 6 months. Sometimes it can be a bit more, sometimes it can be a bit less. Depends on the situation and the incentives that might be getting offered. But yeah, sort of as we say up there, and I said before, what the landlord will be looking is for that guarantor to have some assets, sort of earned a decent net asset value, sort of the guarantor that they can call on if required.
Yeah, I often find that it depends on the tenant. If they're an individual, they may be taking a risk on taking on the premises. They might be excited about their business but not sure it's going to work out, so they don't really want to have their personal assets affected potentially with rent arrears and dilapidation, so they would prefer to offer a higher rent deposit and ring fence their liability into a company. On the other hand, the tenant may not have much funds up front, so they're willing to take the risk on being a guarantor because they can't really afford to put the rent deposit up front if they're investing money into the premises and the business.
So on to the property. One of the important things for us as agents to put into heads of terms is to demise the area that's being taken. Sometimes you'll have a building that could be a shop, for instance, with upper parts, and you'll be taking the whole building, which will be quite simple to demise. Alternatively, you may have part of a building where you've got an office. It's quite useful as the agent, one, if you've got plans, to include those, and also specify the exact area of the property, and whether it includes things such as toilets where they're there in the common areas, and whether it's a shared facility, or whether it's demised to the individual property, so that everybody's aware for the upkeep going forward. Also sort of specific rights such as parking, and any benefits that come with the property where that's being leased.
I'll talk about it a bit more further on in the seminar, but the extent of the property has a big impact on the tenant's repair liability. So they're usually required to fully repair the premises, and it depends how the premises are defined, whether it's just the interior skin or the structure, roof and foundations. So
moving on to the term. Lengths of terms of leases seem to vary quite dramatically depending on sort of the reason for letting the property, or who's going into it. In some instances, landlords may want a property to only be let on a short-term lease. Where that's the case, they'll often look for the lease to be excluded from the Landlord and Tenant Act. So there's no automatic right to renew, and no compensation payable if they wanted to obtain vacant possession there. Lengths of term seem to vary. Some landlords like to have a great deal of security and tie tenants in for a long period of time. As I say, others might have a reason for wanting to obtain vacant possession, and that can affect that side of things. You can obviously have break options included. Break notices generally vary between sort of 3 to 6 months. And could be quite useful, as I say, sort of if a landlord is looking to redevelop the site, or they're looking to sort of occupy themselves at a point in the future, and gives a good degree of flexibility.
From a tenant's point of view, one thing I find that they don't understand in the heads of terms is what does excluded from the 1954 Act mean. And once you explain it to them, it really depends on their future plans, whether they want that excluded or within the Act. For example, I've had a couple of tenants recently who are spending £100,000 plus on refurbs, so they don't want to get to the end of the term and potentially be kicked out. They want the right to renew the lease at the end of the term, which is what the 1954 Act gives the tenant as protection. So it really depends on whether they're looking to sell the business as well. If they think they might be able to sell the goodwill of the business, if it's a chippy, or I find that they tend to be quite common convenience store, takeaway premises, they can sell the goodwill of the business as well, and it's much more attractive for a buyer if they've got a lease that they know that they can renew at the end of the term. There are some instances where the landlord can refuse a renewal even if it's protected. There are 7 statutory grounds, which include if they want to redevelop the property or occupy the premises for themselves. And then there are other grounds such as they've been persistently late in paying rents, so the landlord can validly object to a new tenancy. But in the case of redeveloping and occupying themselves, the tenant will be entitled to compensation based on how long they've been there and the rateable value. So it's much more beneficial for a tenant to have the lease protected within the Act than excluded. Moving on to break rights. So traditionally, there were no break rights in leases back in the 50s and 60s, and they've become more common recently in the last 20 years. And there's a couple of cases which have highlighted how contentious they've been, because break clauses tend to result in lots of cases that have gone to court. For example, the landlords would like to have the break conditional on various elements. These were traditionally payment of the rents, giving up vacant possession, and complying with the tenant covenants in the lease. Now, the third one's very onerous for a tenant, because potentially, if it's a fully repairing lease, the landlord could could void the break on the basis that there's a missing screw or something very minor. So lawyers tended to amend the clause so that it was material compliance with the tenant covenants, in particular the repairing covenants. And this was actually tested in court. The case was Fitzroy House versus Financial Times. So Financial Times were in a massive building in London, £600,000 per annum rent, and they exercised a break clause. And one of the preconditions was that there must be material compliance with the tenant covenants. So they carried out £1 million of dilapidations. The Financial Times tried on several occasions to contact the Fitzroy House's surveyor to agree the specification, but they refused. Fitzroy House had in fact prepared their own specification, but they didn't reveal that until after the break date had passed. So much was at stake, and when the break date passed, Fitzroy House argued that there was £30,000 worth of dilapidations there, and therefore the break had been voided, and they had to stay on for a further 6 years, paying £600,000 per annum. So when it went to court, the judge ruled that as long as the landlord could re-let the premises immediately afterwards, then the break condition had been materially complied with. And he found that the £30,000 of dilapidations, although that seems quite a lot for a massive building, it was considered minor, and therefore the landlord wasn't entitled to void the break. Nowadays, the Code for Commercial Leases recommends only two preconditions: payment of the annual rents and giving up occupation. And if there's any dilapidations, then that can be dealt with separately and it wouldn't affect the break. So when I'm acting for a tenant, I always insist that those are the only two preconditions. Another case concerning a break date was the Marks and Spencer's case. So they successfully exercised a break, and they, when it says the precondition about paying the annual rent, it means that you must pay to the next quarter day and then claim a refund if the break date falls between the quarter days. I think their rent was about £1 million, so it was quite a big sum that they were trying to claim back. And the court ruled that because there was no provision in the lease saying that the landlord had to refund, then they didn't have to. So nowadays lawyers tend to put a provision in the break clause that the landlord has to refund any payments that are made over and after the break date.
So moving on to rent and rent reviews, sort of from the landlord side, obviously with a rent you normally try and get as much as you can. However, it's always a bit of a balancing act at the same time, because if it's too high and not sustainable, you're not going to be getting paid your rent by your tenant. So sort of it's always a case of having a degree of sort of sensibility there. Normally with rent, you're seeing it as a fixed rent. However, it can be stepped over a period of time where it might sort of go up by £1,000 a year until sort of the next rent review. One thing we're seeing a fair bit of at the moment is base rents with a turnover top-up, which is de-risking situations for tenants. However, is getting units occupied for landlords where they might not otherwise let the property. Finding this generally sort of on bigger premises, and institutional landlords are the ones that sort of feel more comfortable with this, more so than sort of independent landlords. Moving on to VAT, it's quite an important thing to sort of consider sort of as a landlord, whether you want to be electing your property for VAT. There's obviously sort of big benefits sort of in that respect. where if you carry out works on the building, you're able to claim the costs of those back, or claim the VAT back on those costs. However, where you've got tenants, for instance, where their turnover might not exceed the VAT threshold, what you've got to sort of factor in is that those tenants are going to be effectively paying an extra 20% more in rent that they're not able to claim back. Also, when it comes to selling a property sort of in the future, if the property is vacant, sort of from a cash flow perspective, the purchaser there would also be sort of looking at sort of spending that VAT, raising that money, although obviously they will be able to look to reclaim that over the period of time. Did you want to jump in? I probably jumped from one to the next there.
Also, VAT is quite relevant with SDLT. So you actually have to pay a tax on a tax. So you pay stamp duty land tax on the VAT inclusive rental figure, which seems unfair, but that's the law. When you're giving the budget to the tenant at the outset, it's important to know whether VAT is payable, so you can accurately assess how much stamp duty land tax there will be. Like Max said, there's a number of ways of reviewing the rents. Fixed, I find the most common is open market, which is upwards only, so it's the higher of the passing rent or the market rent at the time, and that's either agreed between the parties or in default referred to a surveyor, like I'm sure a number of our guests here. RPI rents, I'm seeing RPI CPI rents, which is retail price index or consumer price index, and they tend to be every anniversary, and they're based on inflation or customer spending. And then, as Max said, turnover. I don't see them. I've seen a couple in the last year, a couple of years relating to restaurants. They don't know how they're going to perform, so there's a base rent and then a top up if they perform better than expected. It's important to note that rent review is often, time in a rent review is often not of the essence like it is a break date. So break date, you have to serve it within the notice period. Rent review, it often says in the lease that time is not of the essence, and therefore that means the landlord can instigate it further down the line. I've got a case at the moment where our client, the landlord, has just woken up to the fact that there was a rent review a couple of years ago, so negotiating it with the tenant, so potentially he could claim not only the backdated rents from the rent review date, contractual rent review date to the date it's agreed, but also interest on that, which is usually anything from base rate to 2% above it.
I think, just the only other thing dropping in on was rent-free periods, which I don't think we'd sort of addressed. They seem to sort of vary at the moment, sort of depending on the properties. Again, sort of with sort of independent landlords, we're seeing sort of rent-free periods around sort of the 2 to 3 month period. With bigger, more institutional landlords on sort of larger schemes, these can be sort of bigger than that, and sometimes you've got sort of capital contributions from landlords sort of being thrown into the mix for refurbishments as well. But it varies from property to property and very much sort of based on supply and demand, in the sense of how many people you've got after a property, as opposed to sort of trying to get rid of a property where there's no demand and landlords have really got to throw incentives at it.
Yeah, if a tenant is taking on a shell, they obviously want to do their fitting out works, and they don't really want to be paying rent whilst they can't trade, so it's an important consideration for the tenant too. You want to do it?
So coming back sort of from the guarantor position, again, obviously looking at rent deposits, sort of, as we say, sort of generally range between 3 to 6 months in terms of the amount. Big question sort of in negotiations is often, when will I get my rent deposit back from tenants? Landlords obviously want security for as long as possible. Tenants want cash back in their pocket as soon as possible. And sort of with that, one of the common sort of rules is it can sit there for a period of time, and providing the tenants complied with the reasonable terms of the lease, some landlords will return it. Then a common sort of formula that's used is when a tenant can show net profits equal to 3 times the annual rental. This formula is sort of the view that the business is running well, and the landlord should be sort of fairly safe. But again, it can be sort of negotiated that either sort of half of the deposit's returned or all of it, but it's down to sort of the personal preference of the individuals involved and sort of the backup with guarantors and the company that might be taking the lease.
So do you find when you're doing drafting the heads of terms that when it's returned is included within the heads of terms if it's going to be returned early, or is that sort of...
It's one of those things where I think sort of the tenant normally specifies sort of the return of it because the tenant will be the party that's pushing for it. In some instances it will remain silent, in which case the view is the rent deposit sits there for the term, but it can be a case that sometimes the solicitors will pick that up after heads of terms have been issued, and it can be another point that gets negotiated afterwards.
Does it have to be in a government type of account, the deposit, or does it go in the...
No, on commercial deposits, quite often in the landlord's account, but you can quite often have sort of a designated account for that, would you say, Hamish?
It'll either say a separate interest-bearing account or just an interest-bearing account, so often the landlord doesn't want to go through the hassle of setting up a new account, so they'll just lump it in somewhere. And as long as they're calculating the interest, because they're obliged to pay the deposit back with interest if the tenant hasn't defaulted. But it's not like residential schemes where it's very regulated. From a tenant's perspective, I wouldn't put this in heads of terms, but I'd usually amend the deed so that the landlord has to give the tenant 7 days notice to remedy any default before they dip into it, because once they dip into it, then they've got to top it up within 10 working days. So that's all I have on rent deposits.
Okay, so moving on to services and service charge. With buildings, this will vary depending on the setup of the building, whether it's a standalone building, or alternatively whether you might happen to have sort of a number of parties within the building, where you have landlords or their managing agents will set up a service charge. With a service charge, you'll have the shared costs of the building sort of within that, and then it should be generally based on a percentage of the area that you occupy within the building, so that everybody's paying a fair proportion of their costs. What you'll quite often have is the lease that the party will be taking in a shared building. They will have a repairing obligation to put and to keep in a good and substantial state of repair the internal part and shop front if there is, and then it's the remainder of the structure of the building where they're paying their percentage to the upkeep, sort of as part of the shared costs. As we say out there, so sometimes you can have a cap on that depending on scenarios. What I've quite often seen is landlords will like to give themselves a little bit of leeway, so there's a little bit of comfort from the current figures in the service charge, and then quite possibly have the increase linked with RPI annually, so that as costs go up, the landlord's not at a shortfall.
Service charge is an important point for tenants because it's an unknown liability. So I always get asked how much is the service charge going to be, and all we can do is provide the budget that's been produced by the landlords. But a very important question to ask the landlord is whether they're expecting any unusual or large expenditure in the future, because the tenant could be hit with a large service charge bill at the end of that service charge year. So that's important to cover it as part of the due diligence. Ideally, you'd want to try and agree a cap. From a tenant's perspective, you'd like it in the lease so that it applies not only to any assignees but potentially on any renewal. And as Max said, it's often linked with RPI, so the cap can increase. But if I'm acting for the landlord, I will say we'll agree it if the landlord's happy to, but we want it in a side letter that's personal to the tenant, which means that if the tenant assigns, it no longer applies, and it won't apply to any new renewed lease under the 54 Act. You know?
So moving on to insurance, with the insurance and the heads of terms, in terms of the building insurance, this is something that the landlord will always take out, for the reason being that if a tenant decided they didn't want to pay the insurance and the building burnt down, for instance, the landlord would be at a loss. So it sits there as the landlord's responsibility. However, they will reclaim that from the tenants. Quite often tenants will say, I want to take that out because the landlord's using their insurers and I can get it cheaper, but the rule of thumb is the landlord insures, and then the tenant pays a fair proportion based on sort of the part of the building they occupy.
Yes, so the landlord will not only want to insure the building to protect its capital investment, but also loss of rents, and that's usually up to 3 years. So if the building does burn down, they've got the rent paid whilst it's being reinstated. So from a tenant's perspective, you'd also want uninsured risks covered as well, because there are some risks which are not standard on a policy. A prime example is terrorism. So in London, you'll probably insure your building for terrorism as standard, whereas down in the sticks, it's probably not so much of the risk. So the importance of that is that the tenant is usually required to repair the building except for any insured risks. So you'd want that insured risks and uninsured risks excluded. And also the rent ceasing provision when the property is damaged or destroyed for a tenant usually only applies to insured risks. So again, you'd want uninsured risks covered so that the rent is not payable whilst the tenant can't use the building.
So in regards to the use, we've had some changes on use recently. Sort of last year, Boris sort of brought in the new E-class use, which encompassed a number of pre-existing uses such as A1, A2, A3, and some D1, D2s and B1s. In some instances, this has made life a lot easier for us, but in others, sort of it's created sort of further complexities. In the heads of terms, what we will sort of state previously, we'd have had a scenario such as where you'd have had a shop that would have been an A1 use as retail, and landlords would have probably been a lot more relaxed in allowing the user clause to include any other use class within Class A1, because it was quite specific and your A1 uses were generally quite non-contentious, and the landlord wouldn't unreasonably withhold that. Now we've got the Class E use, it's a much broader spectrum. So from a landlord's perspective, I think sort of what we'll probably see going forward is a lot more closed user clauses, where in the heads of terms and the lease, it particularly specifies that whilst the property, the use is within Class E, it will be specifically for that use, and more so at the landlord's discretion. For instance, if you had a bookshop within Class E, you could, if you're allowing any other use within Class E, in theory, you could turn it into a restaurant. And many landlords might want to sort of protect themselves in that sense, particularly if they've got residential above the property, because if you ended up with a Indian restaurant or a fish and chip shop underneath your flat, it would probably devalue it. It might affect how you're able to mortgage the property as well. So I think sort of on that sort of side of things, we'll see more restrictions. Likewise, in terms of sort of hours that businesses operate, again, it can be a scenario if you've got residential above. I've recently had a situation where a client had a previous tenant in the property, and they had a sort of coffee shop bakery, and the client lived above the property, but they were getting deliveries every day for the last 5 years at 4 o'clock in the morning. So where I'm acting for this landlord, he's now said, I don't want anything like that where I'm going to get disturbed. I want a nice clean use going into the property. So that's sort of probably a big thing. The other side of that is you'll have some landlords, particularly on schemes where they've got other units, where they may have stay open clauses, insisting that the premises do trade, whether it be 5 days a week, 7 days a week, within certain hours, so that they don't end up with a scheme that's looking tired and depleted and empty.
Yeah, having a restrictive use, it can be a double-edged sword. So the tenant will want to be able to assign the lease to, if it wants out of the lease and there's no break, it will want quite a variable option to be able to assign the lease to different businesses. So having a restrictive use clause could affect the ability to assign, but also for the landlord. If they have a really restrictive use clause, I believe that could affect the rent review in a hypothetical lease. I'm sure one of our rent review valuers, as part of our guests, will be able to comment, but that could have an adverse effect on the rent review. And also, from a tenant's perspective, you've also got to think about your business. So I'm acting for a client at the moment who are taking on a Greek restaurant or they are going to open up a Greek restaurant in a shopping centre. So they've agreed with the landlord that they won't grant any new leases to any Greek restaurants within the shopping centre, which could adversely affect their turnover. Yeah.
All good?
Yeah.
So assignments and underleases. Here, sort of, we've got a scenario where landlords are trying to sort of protect themselves going forward. Normally, what you will look for is to be fair and reasonable at the same time. So, sort of in the heads of terms, we would normally specify that the leaseholder is able to assign the lease to another party, and landlords not to unreasonably withhold consent. So in that respect, normally sort of the degree of reasonableness would be where a landlord's in no worse position than they are sort of with the existing tenant, with a new tenant coming in. So that's the position there. With an assignment, it's normally just in whole, because you don't want to be assigning half of the property, as that could be very messy. Similarly with underlettings, you can have sort of an underletting of part. However, it's better from a landlord's perspective if that is sort of kept to a certain demise, where you're boxing off a room and saying this is the scenario. Likewise, you'll also probably sort of look to have any underlettings like that sort of on leases outside the Landlord and Tenant Act, so that the tenant's not got any rights, where in a worst case scenario the head tenant might fold and a landlord's left with a building where they've got one tenant sat within it that is problematic.
From a tenant's view, you want to try and amend the lease so that the conditions and circumstances are as limited as possible, so that they're able to assign. Generally, the conditions are that the tenant must enter into an authorised guarantee agreement, guaranteeing the incoming tenant's obligations under the lease. There must be no material breaches of covenant, and the rent must be up to date. And the leases will also provide that the landlord can normally insist, if reasonably required, on a personal guarantor. I always amend this so that it's only if reasonably required, because if the tenant is assigning to a company that's vastly financially superior, then it would be unreasonable to insist on a guarantor. The tenant may wish to underlet parts. I've just acted for a landlord where they're acting to a store, and there's a first floor, and the tenant wants the ability to have yoga classes on the first floor, so we've agreed to the right to underlet part. Sharing occupation and concessions. So if you go into Boots and you see all the makeup stands, they're all concessions on licences. And Boots doesn't want to have to keep on going to the landlord to ask for a sublease every time they want to grant a concession. So there's usually a provision that, and provided there's no relationship of landlord and tenant, the tenant's able to grant a concession without the landlord's consent. Moving on to Argas and Gargas. So before 1996, the tenant's liability under a lease continued throughout the lease. So it was the original tenant who remained liable for the whole period of the lease, and often leases were 20 years plus at that time. And then the original tenant, if there was a breach by a subsequent tenant, would have to rely on a string of indemnities. And the Landlord and Tenant Covenants Act 1995 brought in a rule to try and make that fairer. So they said that if you assign the lease, you're required to guarantee the incoming tenant's obligations, but once the lease ends or that assignee assigns themselves, you're off the hook. So the guarantee that a tenant's required to give is an ARGA, an authorised guarantee agreement, and it usually provides that if there's any default by the incoming tenant, the landlord can then look to you to make good that default and even take on a new lease in your own name or the company name for the rest of the term. Gargas are where you have a guarantor of the original lease, so it's a company and a guarantor. So if the tenant assigns the lease, the landlord can require the tenant to guarantee the incoming obligations under the lease, but also the guarantor to guarantee that outgoing tenant's obligations, if that makes sense. There was a case law where landlords were trying to get the guarantors to personally guarantee the incoming tenants themselves, bypassing the tenants, but that was ruled void. So, also important to note when you're acting for assignees that they'll inherit the liability under the lease. So if you're taking on a lease that's got, say, 2 years left and it's a fully repairing lease, it's important to get a survey in just to check, if they're going to be inheriting lots of dilapidations that they could potentially be landed with, but they did not cause. Anything further to add?
No. Do you see schedules of condition very often?
Yeah, so we're just going to deal with that now, actually. So it's an important point to consider for the tenant, for sure.
So, as I was saying before, in terms of repair, it's a common misconception that when a party goes into a property, as is the case with residential, the tenant's not got to put it into any better state of repair than it is, which is not correct. When they take on a lease, they have actually got to put and to keep in a good, substantial state of repair. So from a landlord's perspective, if the building isn't in a full repairing condition, it can be onerous to the tenant there. But from a landlord's point of view, obviously you want your tenant to come in and take a full repairing and insuring lease, because the landlord is then able to put that onus sort of on the tenant there. Go back to before, it's important to make clear the extent of the demise, and how sort of the repairing scenario is structured as to whether you've got a total responsibility to the whole building, or you've got a responsibility to part or a percentage of the whole. Again, so another misconception is a lot of tenants come in and they'll look at a building and say, I've got the ground floor, therefore I've got to deal with all the walls around my building, but I've got no responsibility to the roof. When in actual fact what they've generally got is a percentage of the whole to the whole. So sort of an important thing sort of for them to sort of consider there in that respect. Sort of where you say schedule of conditions, it's something that is being sort of advised a lot. Solicitors sort of are advising their clients in that respect, and where a party has a survey, it's becoming quite a common scenario. In some instances, surveyors will be sort of employed to sort of carry that out. In others, sort of many tenants will actually go round and sort of take a photographic schedule themselves, which will be passed to their solicitors to sort of add to the lease.
Yeah, as Max said, tenants don't often understand what fully repairing means, because it's a legal phrase. So my old boss used to say that the way to describe it in layman's terms is that you have to put, keep and leave it in A1 condition according to its age and type. So pretty much mint condition, but you've got to take into account if it's a warehouse or how old it is, if it's a listed building, for example. So it can be, you can get hit with a large dilapidations bill if you take on a fully repairing lease. So we always recommend a survey just to check the extent, and then the tenant can make a decision whether it wants to try and argue a schedule of condition or whether it's willing to take that and include it within its future budget. As I said before, the extent of the demise is important. If it's a shop on the ground floor, it's usually the interior and the shop front, whereas if it's a warehouse, a standalone warehouse, you're looking at the whole extent. I had a client who got hit for a six-figure dilapidation bill on a warehouse that he had taken on previously, and now he will only move into warehouses for his business, which is always expanding, where there's a schedule of condition. If the property's in particularly bad state and the landlord hasn't got the funds to put it in a decent state and just wants a tenant in there and collecting rent, you occasionally see wind and watertight, which is simply that they've got to keep it from leaking. I've already mentioned about insured and uninsured risks excluded. It's important from a tenant's point of view that in the lease it says that they're required to repair the property, but not if the damage has been caused by an insured or uninsured risk. And dilapidations and asbestos, there was quite a big case recently which highlighted the potential issue of contamination from asbestos containing materials. So this was Pullman Foods Limited versus the Welsh Ministers, and it was heard in 2000. In this case, the court was asked to consider whether the tenant had breached its yielding up obligation owing to the contamination of property by asbestos materials. So Pullman Foods was the tenant of the property on Swansea Dock, and the Welsh ministers were the landlord. In the usual way, the tenant was required to leave the property at the end of the term in good and substantial repair and condition. The tenant carried out reinstatement works, which involved demolition and removal works, and they disturbed asbestos, and those asbestos-containing materials contaminated the rest of the property. As a result of this, when the lease term came to the end, the property was contaminated by asbestos, which required expensive remediation works by the landlord. And the court held that the presence of asbestos-containing materials in the site was a breach of the tenant's obligation to yield up the property in good and substantial repair and condition. He held that the word condition demonstrated that the obligation was capable of extending to doing works that went beyond just repair, and concluded that the landlord could form his own judgment as to what would be required to satisfy the appropriate standard to constitute good condition, as long as it was reasonable. So this meant that the tenant was liable for potentially substantial remediation sums in removing decontamination of the property, which is quite scary for a tenant. So again, when carrying out a building survey, I assume from our building surveyors in here, you check for potential asbestos containing materials, or is that included just the
as far as visible, really.
Yeah. But always important to get asbestos survey before you complete the lease as well, because that will be specific and highlight any materials that have been tested by that surveyors. But as Simon said, it's only those that are visible, and they could be hidden and only found once they carry out the reinstatement works.
So on to alterations, both sort of structural and non-structural. Again, it will depend on the sort of scenario of the lease, whether you've got sort of a longer term lease or possibly a short term lease, as to sort of how sort of landlords will view this. But generally, on a sort of a longer lease, non-structural alterations don't always require landlord's consent, whereas structural will always require landlord's consent, but it varies from scenario to scenario there. Likewise, with something such as signage and general tenant fit-out works, sort of a lot of landlords will want to know what those are going into the property. Particularly, again, sort of as you go to sort of institutional landlords, they can be sort of quite sort of fussy in this respect, that everything is signed off there. It can actually be to sort of the tenant's benefit sometimes in these scenarios, where these all get signed off as part of the legal process, because if the tenant goes back post-completion, the landlord and their solicitors will quite often charge sort of additional costs for licence for alteration to sort of attach that to the lease going forward. So it can certainly be beneficial for sort of tenants to get a lot of these things ironed out early days and put into the lease, so that everybody knows where they stand.
Usually the lease will provide that structural alterations are prohibited unless it's been specifically agreed beforehand, and non-structural alterations are allowed, but with the landlord's consent. And as Max said, there'd be usually the surveyors approving plans and the legal fees for a licence for alterations. I always try and carve out of that consent obligation partitioning. So if they want to move partitioning, put up partitioning, relocate it, then that doesn't require consent, and I generally find that landlords are happy with that. Again, important that signage is included within the consent obligation, because leases usually provide that any signage must be with the landlord's consent, so getting that included within the original negotiations is fairly important.
Then sort of going on to tenants fitting out works, again sort of I think sort of licence for alterations we've somewhat sort of covered just before, but where there are certain works carried out that sort of benefit the property and add value, obviously a point to sort of agree is whether these are disregarded at rent review, as tenants would feel that it would be unfair for landlords to benefit sort of from something that they've contributed sort of towards, for instance, if you put a mezzanine floor into a property that's at the cost of the tenant, they wouldn't then want to be paying additional rent for the extra floor space that's in the property. Sort of going back to sort of earlier with incentives and rent-free, landlords will in some instances make a capital contribution to works, which sort of the tenant can then benefit from. But again, that will be a point for negotiation in regards to sort of whether it's disregarded at the rent review if in turn the capital contribution is actually paid for these works as opposed to the tenant paying for them.
Yeah, so adding on to what Max said, I'm acting for a landlord at the moment who let their building to a bank, and the bank, as lots of banks are doing, they moved off the high street, and now it's going to be let to a fashion retail store. And because it's a bank, it's very specific. You know, you've got an ATM machine and various holes like that, and so that the landlords agreed to carry out substantial works first, and then the lease completes and the tenant carry out their own fitting out works with a rent-free period. So, and that's usually covered in an agreement for lease, because the landlord doesn't want to carry out the works unless they know that the tenant's going to take on the lease.
So where you have a scenario where there's landlord's works, as Hamish was just telling us, you can have an agreement for lease, which is very much an exchange of contracts as you would sort of see on a property purchase, in a similar sense, where all parties are contracted to proceed, but sort of they haven't actually completed at that point. So it gives the landlord confidence to go into the property, spend the money, carry out the works for the specific tenant that they've contracted with, sort of being in the comfort that if the tenant change their mind, they can't just walk away from it. They have got sort of financial commitment to the property. We find sort of an agreement for lease is quite a beneficial scenario, because particularly at the moment where you've got a lot of tenants leaving properties, you're able to sort of market 6 months before the end of the lease comes to an end. So you can have a scenario where you might market for a couple of months, agree terms with the party, but they can plan going forward so that when the existing tenant leaves, everybody's in a position where everything's teed up, ready to complete, and go into the property following sort of vacation from the existing tenants.
Yeah, if a property's stated on the heads of terms as let as seen, it's important for a tenant to know what current fixtures and fittings in there are landlord's fixtures and fittings, which will usually be covered under their repair obligation, and what are perhaps previous tenants' fixtures and fittings, which they can either remove or use at their expense.
So onto the conditions. So where you have a scenario where there might be a sublease or a long leasehold interest, it may be required that you need to obtain superior landlord's consent on the property. One thing to sort of bear in mind with that is also that there can be additional costs sort of involved in that scenario. I once dealt with a property not far from here where the annual rent on it was £4,000 a year. We managed to get a small premium on it, but we had a scenario where our client owned a long leasehold, and then there was a freeholder above, and the costs for the assignment or the letting of the property ended up exceeding £5,000 because it was so complex, which was sort of ironic, as I say, because the annual rental was only £4,000 a year. So my client wasn't overjoyed by it, but had to live with it, and luckily he ended up getting quite a long lease. In many instances, both from the landlord's perspective and the tenant's perspective, board approval is sometimes required. So you'll have an instance where a party at a certain level has agreed in principle, but it is still subject to board approval. And then sort of, as Hamish was mentioning before, sort of a big thing will be subject to survey, which is a good thing to lay out right from the beginning, because then everybody knows where they are. In many instances, tenants will come in agree a deal, and then at the 11th hour somebody will say to them, have you had a survey? And it throws a whole can of worms into the mix, where there's a load of problems at the 11th hour when everybody's ready to try and complete the transaction. So it's beneficial if that can be ironed out early and surveys carried out early if somebody is going to have one.
So when acting for an under-tenant, do you find that when you do heads of terms for a sublease that you've got the freeholders involved already and they're mentioned on the heads of terms and they've sort of given consent in principle subject to licence, or is it generally no?
Normally sort of progresses as the matter goes on.
Yeah, so it's important to obviously advise the under-tenant potentially what they could be liable for. Usually under the lease it'll say the landlord can ask for a guarantor, because as Max said earlier, if the head tenant goes bust, then the under-tenant can apply for relief from forfeiture and become the direct tenant of the freeholder. So that's why it's important that the freeholder is given the ability to consent to the under-tenant. And also what rent deposit they require, which could be an important consideration.
Costs, fun one. So when we're assigning leases, rule of thumb that we've always generally adopted is that the incoming tenant, we will try and get them to pay costs, whether it be an assignment or a new lease. Reason being that where you've got a landlord or a party looking to assign their lease, if a deal falls through 99% of the time, it's normally because it's the incoming party changing their mind, not the outgoing party. So we'll always sort of try and get that sort of sorted so that there's protection for our client as I say, the landlord or the assignor. Normally this is something that could be capped, and sort of most parties seem to be sort of happy with that scenario. Where you've got a situation where you've got several layers of landlords, it can become quite an expensive scenario. So it is very much sort of a balancing act. In some instances where an incoming party isn't necessarily prepared to pay the costs, but they're prepared to pay the costs on the basis they don't complete the lease, which works quite well because again it gives landlords sort of comfort in that respect.
Yeah, I tend to find that it's supply and demand. Who wants to let the property or take the property on more? If a landlord's got lots of tenants interested, they may say, well, I'll let it to you, but on the basis you pay my costs. Whereas if it's been empty for a while and they're desperate to get someone in, then it's usually both parties pay their own costs. As Max said, if it's the tenant paying the landlord's costs, then you need to be careful about giving the undertaking, for the wording of the undertaking, because you need to ensure that it's, from a tenant's point of view, that if the landlord withdraws, that undertaking doesn't apply. And also, if something, I sometimes see if something adverse is revealed by the title or the searches that would prevent a reasonable tenant from proceeding, then obviously they don't want to have to pay the landlord's costs. But it really depends on the landlord's position on that one. And then finally, the most boring head of term. Yeah, just it's who you conveyance. So you don't have to get a conveyance. I tend to find that some tenants would prefer just to act for themselves. We've had a few cases in the past like that. Yeah. Whereas if both parties are instructing lawyers, then that's where they're set out in the heads of terms.
Yeah, no, sort of, yeah, very much the case. You always need sort of one conveyancer involved generally, I think, to sort of drive the situation. But yeah, recently I've seen a lot of tenants where sort of they've not bothered to have a solicitor involved in the transaction. From a selfish sort of perspective, as an agent and acting for landlords, it makes things go through generally sort of a lot quicker. But obviously from a tenant's perspective, sort of they're open to sort of making mistakes and sort of possibly not getting the best deal for themselves.
Yeah, I mean, considering the pitfalls we've talked about, you know, if you don't get legal advice, then you're potentially signing something that you don't know how much you're going to be liable for in the future. So in conclusion, as we just said, it's important for the tenants to get legal advice on the heads of terms at the outset, because there's lots of legal terminology in there that they might not fully understand. And if we can nip it in the bud at the heads of terms stage, then I tend to find that the transactions go through much better. I always highlight to the tenant the two main unknowns, because you know what the rent's going to be payable, apart from obviously reviewed rent. It's dilapidations and service charge. So you want to carry out your due diligence, find out how much the service charge is likely to be in the future, and also suggest a survey just so that they know how much they need to budget for if they're taking on a fully repairing lease. Anything to add?
Yeah, no, all good.
Thank you for listening.
Thank you.